Okay. Um, Hi, my dear students. Welcome you all to HM Commerce Education, and this is CA Mani Chandana. So, we had started with Chapter 1 Indian Regulatory Framework in our previous class, and today, before continuing, let's just revise whatever we have done in our earlier class. Okay, so let's just revise. Okay, yeah, fine. So what did we learn? What did we learn in our first class? What was the first topic? Okay, why is CA, sorry, why is law a subject in your CA course? Yes, correct. Remember everyone? Yes, also I want you to see whenever I try to revise or whenever I explain, make it a habit to write on your own. Use your own language or whatever. Whenever I try to explain, just make down, just write down next to the paragraphs or wherever you find space. Make sure you write it in your own language so that whenever you read it the next time, instead of just sitting and seeing the classes or watching my classes as though you're watching a movie, it's always better you write down the points whichever are necessary, and so that you feel more confident and while revising. And it's always a very good habit to write down whatever you understand from your class. Okay, it always boosts your confidence when you sit for your revision, right? Getting my point? Make sure you write, you just, or at least underline or do something to your book so that at least your book looks as though you have studied that particular chapter or that particular unit. Getting it? Okay, so yeah, not wasting much of your time, let's start off with your revision. Okay, the first topic being, why is law a subject being introduced in your CA course? Okay, what was it? What did we learn? It is essential because we chartered accountants are the first level of contact on many legal matters for our clients. Yes or no? Yes, remember? I hope you all remember. Also, taxation. You all have a subject called taxation. Yes, not now. Yes, you will have. Yes, income tax, GST, all of these. So these are also laws. So so that's what they're trying to tell you. If you have to become an expert in your further, after you become your charter, after you clear your CA course and you want to specialize or you want to just practice in this particular area called taxation, it's all. So they're trying to tell you even this taxation are also laws. I told you Income Tax Act 1961, GST Act 2017. These are also acts, meaning laws. Yes. Okay. Next, not much. Next, yeah, Code of Hammurabi, and we learned Code of Hammurabi and the 12 tables. Yes, quite important. Okay, 1 second. Code of Hammurabi and 12 tables. Code of Hammurabi, why is it famous? Because it is the oldest law in written form, whereas 12 tables, it is the first most detailed code of any of the civilization. Correct? Where was this Code of Hammurabi? It was in Babylon. Here it is in Rome. Correct? Yes. Code of Hammurabi 1792 BC to 1758 BC, whereas 12 tables was in the period 450 BC. Yes, till here clear? I hope we are all clear. Yes. Also, in case of Code of Hammurabi, where were these? Where was this code? You know, engraved. It was engraved on bulky stone slabs, and it was made to place on these stone slabs were made to place in different parts of the city, so that the people of that particular country were made aware of. Yes, and yes, fine. He also appointed judges to check whether the public is following the laws or not. Here, the purpose of 12 tables, I'm talking about 12 tables now. The purpose of these tables was to protect the rights of the public and provide remedy for wrongs. Okay, next. Next, what did we learn? We learned what is law. What is law? Law is a set of obligations and duties imposed by whom? Imposed by our government. For what? For securing welfare and providing justice to the society. Correct? Done? I hope you all are clear till here. Yes? So if you are clear and if you have done with and if we are done with the revision, let's move on to the next topic. move on to the next topic. Now, what is this? Sources of law. What is this? Sources of law. The main sources of law in India are Constitution. Children, again and again, I'm trying to tell you that, whenever I'm, you all know that I explain using the material which I have compiled. Basically, this is nothing but your ICA material. I have not deviated from your material, the study material of the institute. I have not deviated from your institute material. But the only effort I have put in compiling this book is that I have made the paragraphs into various number of points, so that it is more easier to you for you all to learn and interpret this particular subject. Yes, and also you can refer your study material, your institute study material, but always whenever I try referring to the page number, this is fine. But when we move ahead in the other chapters, it might be a little difficult for you. So make sure you are at least seeing or referring to the page which I am explaining, so that you can actually you can relate with what I am trying to tell. Just don't listen, just don't wear your earphones, sit in one place and see watch this particular lecture as a movie or something. No, that does not help children. That will never help, because after a while, maybe after a week or so, you will it's natural tendency of humans to forget whatever we even a movie, very interesting movie you have seen, and you again try to recollect what happened. You will not be able to recollect, even though with so much of concentration, with so much of interest you watch that particular movie. You will not be able to recollect what happened scene by scene. Will you be able to recollect? No. Movie only you cannot recollect. Just imagine when it comes to studies anyways, you will not sit with so much of concentration or so much of interest. It's just that you have to do it, you will do it. No, that should not be the case. But still it is studies, no, can't help. Not Netflix or Amazon. So what I'm trying to tell you all is that make sure you keep a book and mark whatever I'm trying to write, whatever I'm trying to mark here in the book. Here in my book, you can purchase this book, or else you can use your study material. uh, it's your choice. But still, but then I want you all to have a book, have your pen, underline, write, and be involved with me during the session. Yes, so that it will help you later when you sit for your revision or whatever it is, right? Please, I ask, I want to just, this is a sincere request from my side. Please make sure you have a book with you along with your pen. Okay. Okay, from sources of law. From sources of law. Yes. Okay. Fine. Come to page number 3, sources of law. Yeah. The main sources of law in India are the Constitution, the statutes or laws made by the Parliament and the state assemblies, precedents or the judicial decisions of various courts, and in some cases established customs and usages. Okay. So let's read one by one in detail. Okay. The main sources of law in India are the Constitution. Children, what is Constitution? You all know. Civics, school, civics. Yes. What is Constitution? Constitution is the supreme law of India. It is the supreme law of India. Yes or no? It is a political frame based on which the laws of our country are formulated. It is a political frame based on which the laws of our country are formulated. This gives the power, the Constitution gives the power to the government to formulate laws. Yes, there are many articles in the Constitution. There are around 448 articles in the Constitution, and each of these articles gives us power. Okay, one such article gives the government the power to do what? To form laws. Yes, also the constitution gives us the lays down the fundamental duties and rights of the citizens. Yes, come to page number 4. Let's read about the constitution. Yes, come to page number 4. Yes, the Constitution of India 1950. Oh, okay. Constitution of India 1950. Children, just tell me, when was Constitution, when did Constitution come into force? It came into force on 26th January 1950. Enido, what is 26th January 1950? Republic Day na? Independence Day na? Yes, Republic Day. Yes, everyone. Okay, the Constitution of India 1950 is the foremost law. It is a supreme law. Yes, and it deals with the framework within which our system, within which our democratic system works, and our laws are made for the people and by the people. For the people and by the people. For the people, so we can understand. Okay, the laws are made for the people, but by the people, how? What is how can we make laws? We are sitting here, we are watching the movies, we are playing, we are eating, we are studying. How, when did we do laws? When did we frame laws? They're telling by the people. Yes or no? By the people meaning, children, we elect our representatives during election. Yes or no? MLAs, MPs. Yes. So these MLAs or MPs are involved in framing laws. So indirectly, we are only formulating our laws. Yes, getting it? So these are laws made for the people and by the people. Yes, by the people meaning the people representatives. Okay. Yes. Okay. Now, the Constitution also provides for and protects certain fundamental rights of the citizens, and also lays down the fundamental duties of the citizens. Fundamental rights and fundamental duties you would have studied in your school, civics. Yes. Okay. It also lays down the powers and duties of both the central and state governments. It also lays down the powers. It gives the powers, and it also lays down the duties of not only citizens but also of the state government and central governments. Getting it? Okay. Next. Okay. The laws in India are interconnected with each other, forming a hybrid legal system. What do you mean by this? See, hybrid legal system meaning, see, there are so many laws. Say, for example, civil law, there is common law, there is religious law, which all of these are interconnected in our country, making us form a hybrid legal system. Making us form a hybrid legal system. So, the laws in India are so much interconnected with each other, forming a hybrid legal system. Meaning, there are various laws such as civil law, customary law. There is a common law. There is religious law, making it a hybrid legal system. Getting it? Okay. Now, come back. Come back to page number 3. Okay. Now, we're done with the constitution, the main sources of law, the first one being the constitution. Yes, now, second one being the statutes or laws made by the parliament and state assemblies. Okay, what do you mean by statutes? What do you mean by statute? Statute is nothing but act. It is nothing but act. Act meaning act. Indian Contract Act, Companies Act. Yes, yes or no? Okay, how is this act being passed in the parliament or state assembly? Or in the state assembly? Say, for example, Companies Act 2013. How did this become an act? Okay, let's learn about that. Yes, everyone interested? Okay, come to page number 5. Okay, before even coming to page number 5, I'll just show you all, and let's learn how an act is passed in the parliament. Okay. Okay. Now, first let's read whatever is there in your book, and then let's go back to the PDF, and then let's learn it in a better manner. Okay. Let's just first read whatever is there in your book. Okay. Let's see how much you'll understand. Great. Okay. Now, the process of making a law. The process of making a law. When a law is proposed in a parliament, it is called a bill. Meaning before an act is passed, there is a bill, meaning a draft act. It is still a draft. It has not been notified by the president. So it is still a draft stage, initial stages. Okay. So when a law is proposed in parliament, it is called a bill. Okay. After discussion debate, the law is passed in Lok Sabha. Thereafter, it has to be passed in Rajya Sabha. Then it has to obtain the consent of President of India. Finally, the law will be notified by the government in the publication called Official Gazette of India. Okay, 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 not okay. Fine. Come. Let's read here. Okay, what was this? Bill. What is a bill? It is nothing but a draft. It is nothing but a draft. Yes. Draft Act. Okay. So this is proposed in the parliament. It is proposed in the parliament. Parliament, what is this? Ma'am, what is this, ma'am? Something we have not seen. Only parliament is something. This is the new parliament. Okay. Inaugurated recently. Okay. So proposed in the parliament. By whom? By whom? By the head of the ministry. By head of the, sorry, it's not heard, and it's because of the stylus. Okay. And write it. We'll write it in a neat head of the ministry. Okay, head of the ministry. Say for example, Companies Act 2013. So now, before it became an act, there is a bill. Yes, this bill is being presented at the parliament, by the head of the ministry. Companies Act, head of ministry, you will learn, but for your information, it is head of ministry is Ministry of Corporate Affairs. Ministry of Corporate Affairs. Headed by whom? Headed by Mrs. Nirmala Sitharaman. Headed by Mrs. Nirmala Sitharaman. Yes. Okay. Now, so there is a draft, that is a bill, which is proposed in the parliament by the head of the ministry. Okay. And there is Lok Sabha. Yes. Where all the elected representatives sit. There is the ruling party. There is also the opposition party. Yes, when the bill is being presented in the parliament, first the Lok Sabha has to approve. Yes, after this goes to the Rajya Sabha, upper house. Yes, it goes to the Rajya Sabha, and here also it has to be passed. Getting it? Okay. After that it has to obtain the assent of President of India. Or President of India. She will sign. Yes, after the bill, after obtaining the assent of President of India, after we obtain the assent of the President of India, the law will be notified by the government in the Official Gazette of India. See, now it is called law. Now it is called law. Now it is not a bill. Bill after the President's signature, after the President's assent will become law, will become an act, Yes or no? Yes. So, ma'am, what is this Official Gazette of India? What is this Official Gazette of India? Children, Official Gazette of India is a publication by the government. See, this usually, in the previous years, it used to be in a physical format, but now there's a website. It is in it is a website, the official website, the Gazette of India. The Gazette of India. Okay, see this one. You can Google it anytime, and here you can see. See bills and acts. Here it will be published. Getting it? So once it is published, it is called an act of the parliament. See, the law will become applicable from the date mentioned in the notification as the effective date. So the date which is mentioned in the notification will be the effective date for the act. Okay, once it is notified and effective, it is called the act of the Parliament. It is called what? It is called an act of the Parliament. Yes. Now let's go back to our book. Now it will be simpler. Yes. See. Okay. Come on. When a law is proposed in the Parliament, when a law is proposed in the Parliament, it is called what? It is called a bill. Next, after discussion debate, the law is passed in Lok Sabha. Yes, after the opposition party will obviously oppose. Yes, and the ruling party will obviously defend. Yes, after everything, all of the discussion, everything, the law is passed in Lok Sabha. Later, it is passed in Rajya Sabha, and finally, it has to obtain the assent of President of India. The President of India has to sign. Okay. After that, the law will be notified by the government in the publication, in its official publication called the Official Gazette of India. Now it is in electronic form. Yes, everything is digital. Yes. Okay, fine. The law will become applicable from the date mentioned in the notification as the effective date. Once it is notified and effective, it is called the Act of the Parliament. It is called the Act of the Parliament. Clear, everyone? Yes? Important? Very important. Okay? Fine. Come back. Come back to page number 3. Yes? Come back to page number 3. Right? Okay. We learned what is main sources of law, the first one being the constitution and later being the statutes or laws made by the parliament and state assemblies. Yes, yes, ma'am. Okay. Next, precedents or judicial decisions of various courts. Precedents or the judicial decisions of various courts. Ma'am, what is this? What is this judicial decisions or precedents of various courts? Why is it a source of law? Children, try to understand. Whenever there is a case, say for example A versus B, okay, and this case is being fought, and after many of the hearings, finally a judgment is passed. Finally a judgment is passed, say for example by the Supreme Court of India. Okay, now consider for example I am also in a similar situation. Even I am also in the similar situation of A versus B. The same facts, similar facts. Okay. And now if I go to court, the court will have to follow the judicial decision of the Supreme Court of India. Whatever the decision is passed by the Supreme Court of India, that will be applicable to the entire India. Getting my point? And not only Supreme Court of India, even the High Courts, whatever the decisions given by the High Courts, that will be applicable to that particular state. High Court, obviously, that particular state, whatever the judgments are passed by the High Court will be applicable for that particular state. Yes, and the judgment passed by the Supreme Court will be applicable to the entire country. Getting it? Yes. Okay. Provided the facts of the case should be similar. The facts of the case need to be similar. Now, why all of this? See, children, yes, obviously it saves a lot of time. Yes, similar case happened few years back in India, and the same case now we are also the facts of the case are similar. Yes, why should we go through the process again, like say for example 5 years, 10 years, you don't know how long it will take. But when already there is a case which has happened few years back and a decision is passed by the Supreme Court of India, or say for example a High Court for that particular state, why should we not consider that particular case? Why should we not consider the judgment given in that particular case? Yes or no? Getting my point? So that acts as a source of law. That acts as a source of law. Now come to page number. I'll just we just read that as well. Okay, come to page number 7. Come to page number 7. Okay. Yes. Common law. We're talking about common law. Okay. See, a judicial precedent or a case law is a common law. Okay. Now, a judgment delivered by a Supreme Court will be binding upon the courts within the territory of India. Getting my point? This is what I told you. Yes, the judgment delivered by the Supreme Court of India will be binding upon the courts within the territory of India under the Article 141 of the Indian Constitution. I told you Constitution is the supreme law of India. Yes. See, Article 141. I told you there are around 448 articles. In that, Article 141 says that the judgment delivered by the Supreme Court will be binding upon the courts within the territory of India. Yes, clear? Okay, now, important. The doctrine of stare decisis. It's not stare, it is stare decisis. Okay, the doctrine of stare decisis is the principle supporting common law. It is a Latin phrase that means to stand by that which is decided. To stand by that which is decided. Stare decisis. Important. Stare decisis. So you please stand by that which is decided by the Supreme Court. Yes. Yes. Okay. The doctrine of stare decisis reinforces the obligation of courts. It is the obligation of the courts. So it is a duty of the courts to do what? To follow the same principle or judgment, to follow the same principle or judgment established by previous decisions while ruling a case where very important, where the facts are similar or on all four legs. On all four legs meaning the facts of the case are similar to the previous case. Yes, with the earlier decision. Getting it? Yes or no? Getting it? Fine. Also, one more advantage of this is that, the people are treated equally. Yes, the justice is given to people equally. Yes, see, in once a Supreme Court passes a judgment, and for that the facts are similar, and entire country has to follow that the same judgment. Obviously, we are getting equal treatment. Yes, right? Good. Understood? Yes. Yes, ma'am. Okay, ma'am. Now come back to page number. We'll jump here and there, but you don't have to worry. We will cover the entire chapter. I'll not skip any paragraph or something. It's just that the order will be different, because I'll try to relate certain topics wherein it's easier for students to understand, and it's always better when you relate and study, when you connect and study. Okay, that's the only reason I jumped from one page to the other page, and then I ask you to come back. Don't worry, we are not skipping anything. Okay, once we finish the entire chapter, you can just check if you want. We wouldn't have missed any of the paragraphs or any of the topics. You can recheck. Just trust me. It's going to be fine. Okay, fine. Now, precedents or judicial decisions of various courts. We are done with this. Okay. Yes, and in some cases established customs and usages. This is not of much relevance to us, but what is this, ma'am? Just for understanding, I'll just let you know. Established customs mean being, see, when a certain activity is performed in a certain manner. If it is performed in a certain manner for many times, when a certain activity is performed in a certain manner a number of times, it becomes a custom. It becomes a custom, and certain customs are recognized by law. Few courts recognize certain customs as law. That is not of much importance to us. So to us as in your syllabus. So that's just for your knowledge. I give you that little information. Okay. So fine. We are done with the first paragraph. That is, the main sources of law in India are the Constitution being the supreme law of India, and the statutes or laws made by the Parliament and state assemblies. Statutes meaning nothing but act, which are made by the Parliament. Yes, next. Precedents or judicial decisions of various courts. This also we learnt. Clear? Yes, and in some cases established customs and usages. Okay. Now, next paragraph. Come to the next paragraph. You must be aware that India is a parliamentary democracy. So sorry. Okay. You must be aware that India is a parliamentary democracy. What do you mean by parliamentary democracy? Tell me, what do you mean by parliamentary democracy? Yes, the party with majority of the votes, the party which gets majority of the votes can form the government. Yes or no? The party with the greatest majority in the election, they can form the government. Yes, it is run by the people, basically by the people for the people. Yes or no? Yes. Okay. You must be aware that India is a parliamentary democracy. We have a constitution. We have a constitution which is the basis. It forms the basis and source for all the laws. Didn't I tell you? Yes. The constitution is where the constitution is from where the government gets the power to make laws. So the constitution is like the supreme. Okay, so this forms the basis. This forms the basis and also source for all of the laws. Okay, see, we elect our representatives. We elect our representatives to the parliament as well as to the legislative assemblies of various states. MPs and MLAs. Yes or no? Okay, now these representatives of the people, I have already explained this to you. Okay, these representatives of the people make laws in the parliament, make laws in the parliament or in their state assemblies as the case may be. Yes, that's what we learned. Yes, the Lok Sabha, Rajya Sabha, and then assent of the president. Yes, that's the process of making a law. In this, aren't the people whom we elect involved? They are involved. Yes or no? Yes. Okay. So the representatives of people make laws in parliament or in their state assemblies as the case may be. So the parliament is the ultimate law-making body. So the parliament is the ultimate law-making body. That's what we learned. See, it is called an act of the parliament. So which is the ultimate law-making body? Parliament is the ultimate law-making body. Yes. The laws passed by Parliament may apply throughout all or a portion of India, whereas the laws passed by state legislatures apply only within the borders of the states concerned. This we are very much clear in our previous lecture itself. So the laws passed by the state government will be applicable to the people of the state, whereas the laws passed by the central government or the union government will be applicable to the entire nation. Yes. Okay. If you're done with that, we are moving to the next paragraph, page number 4. Okay, on page number 4. Okay, ma'am, what is this? Come on. The Government of India Act 1935. The Government of India Act 1935, passed by the Parliament of United Kingdom, UK, passed by the Parliament of United Kingdom, is the precursor for the Constitution of India. So even before Constitution of India came into force on 26th January 1950. So prior to that, we had this Government of India Act 1935. We had this Government of India Act 1935. Yes, it defined the characteristics of the government from unitary to federal. What happened? Tell me, where were we? It defined the characteristics of the government from unitary to federal. Meaning, okay, fine. The most important, you can tell, feature of this Government of India Act was that this act established the federal federal system of government, you can say. Okay, Okay, this laid the basis probably. Okay. What is this federal system of governments, children? What do you mean by federal system of government? Federal system of government means the powers are divided between the center as well as the state. Center meaning the union government or the central government or and the state government. Getting it? So the powers are given to both the central government and the state government. Getting my point? Whereas the other form of government would be the unitary form of government, wherein here all of the powers lies only with the central government, lies only with one government, and that is the central government. Example of unitary form of government would be France, China, France, United Kingdom. All of these, they have unitary form of government, whereas we in India have the federal system of government, where the powers are distributed between the state as well as the center. Getting it? Okay, see, read. Powers are distributed between center and state to avoid any disputes. Getting it? Are we clear? Hope I'm clear. Children, I would love to hear from you, because whenever you understand what I'm trying to teach, it's always motivating. It's whenever you comment or whenever you like my video, I always feel happy. I feel happy, and I feel yes, I am trying to help my students, and they are kind of getting benefit from my efforts. Be it the book or my lectures. I really feel happy if you comment and at least like the video. Okay, fine. Anyways, let's continue. In 1937, the federal court was established. In 1937, the federal court was established and had the jurisdiction of appellate, original, and advisory. Okay, the federal court was established in the year 1937 and had the jurisdiction of appellate, original, and advisory. Now, what is this? What is this? Original, appellate, and advisory. Just come open your books, or if you have space anywhere, just make a note of it. I will write down. Okay, and later I'll explain you all. Okay, fine. One second. Okay. Original jurisdiction. I can dictate. I don't know, but how many of you will actually write if I dictate? So if you at least see me doing some hard work, at least somewhere, even you will feel that even you will have to put in a little more efforts and make sure you also write it down. Okay, that's the only reason behind me writing. In the initial classes, I will write, and moving further, I'll only dictate. Okay, fine. Original jurisdiction. Here, write down the court's power to listen, the court's power to listen to a case or a matter, anything, case or matter from the beginning. From the beginning. Okay, original jurisdiction. Fine. Now, next being appellate jurisdiction. Appellate jurisdiction. Okay. Write down the court's power, the power, yes, and authority, power or authority, anything you can write, authority to listen to a case on appeal, on appeal from other lower courts, other courts. Okay. Next, fine. Next is the advisory jurisdiction. Next is the advisory jurisdiction. Yes. Here it is the court's power, the court's power to give advisory opinions, to give advisory opinions on legal questions, on legal questions asked by the government. Okay, asked by the government, or say a president or governor. Yes, okay. Now come back. Okay, I think, okay, fine. Just take a screenshot of this. Take a screenshot of this if you have not completed writing along with me. Okay, and you can write it later because I cannot wait for long. Okay, students, please. Okay, so fine. Now, where were we? Okay, we were talking about the federal court, yes or no? So, see, the federal court was established and had the jurisdiction of what? It had the jurisdiction of the appellate. It also had the jurisdiction of the original and the advisory. Okay, now let's talk about original jurisdiction. What do you mean by original jurisdiction? Original meaning the place wherein the first hearing, I mean, where the case began. Yes or no? Where the case began. That is the original, what? Original jurisdiction. Next comes the appellate advisory. Appellate jurisdiction. This is where the court has the power to listen or to hear the case of the appeal from the lower courts. So, say for example, district court. There is a district court, and the district court passes the judgment, but the people are not happy with the decision of the lower court, and they go for an appeal. Yes, they go for appeal to the higher court. That is, say for example, high court. Getting my point? So that is the appellate jurisdiction. So this federal court had the appellate jurisdiction. It also had the original jurisdiction, and it also had the advisory jurisdiction. What do you mean by advisory jurisdiction? Advisory jurisdiction is the power of the court to give advisory opinions or to give advice to the governor or president. Getting my point? To the governor or the president. Yes. Now, the powers of appellate jurisdiction. Okay, we are now talking about the federal court. The federal court, the powers of appellate jurisdiction extended to civil and criminal cases, whereas the advisory jurisdiction was extended with the powers to federal court to advise on governor general in matters of public opinion. So first we learned what is that original jurisdiction, what is appellate jurisdiction, and what is advisory jurisdiction. What is it? Original meaning the power of the court to hear the cases in the very beginning, wherever it started. Yes, when it comes to appellate, it is the power of the court to hear those cases which have been appealed from a lower court. Getting my point? Next, advisory meaning the power of the court to give advisory opinions or to give advice to the president or the government, to the government. Okay, getting it? See, now we are talking about federal court. I explained what is original appellate advisory. Now we are talking about federal court. What did federal court have? Federal court have had the jurisdiction of all the three. Yes, it had the jurisdiction of all the three. Now, the powers of appellate jurisdiction. Now we are talking about appellate jurisdiction extended to civil and criminal cases. It extended to civil and criminal cases, whereas advisory jurisdiction extended to the power, okay, to advise the Governor General in matters of public opinion. I am making it very messy. Give me a moment. Okay. Wait. Okay. Wait. Appellate, original, advisory. Yes. The powers of appellate jurisdiction extended to what? Civil and criminal cases. Civil and criminal cases. Whereas advisory jurisdiction to advise Governor General in matters of public opinion. Clear? Okay. Now, the federal court operated for 12 years and heard roughly 151 cases. It operated for around 12 years and it heard around roughly 151 cases. Okay. Now, this is important. This is important. The federal court was supplanted by India's current apex court, the Supreme Court of India. Supplanted meaning in the place of. So, in the place of federal court, now we have the Supreme Court of India, which is the apex court. Apex meaning top. Apex meaning the top. Getting it? Fine. Okay. Now we are done with this as well. Okay, fine. Now let's move ahead. Let's move ahead to the next topic. Okay. The people who wrote the constitution, again we are talking about the constitution. The people who wrote the constitution decided to divide the law-making power between the central government and the various state governments. What is this? What is this called? Federal form of government. Yes or no? So, the people who wrote the constitution decided to divide the law-making power between the central government and the various state governments. So, the Indian constitution has 3 lists. It has how many lists? It has 3 lists. Being the first one being the state list, the second one being the the first one being the central list, the second one being the state list, and the third being the joint list. Okay, come here. I just want you to. Okay. Okay, see. This is union list. Union list, yes, state list, joint list. Joint list, the other name is concurrent list. Okay, see, the central government has power to make laws in case of union list. Here, the state government has power to make laws. Here, both. Yes. Okay. Say for example, union list, defense, banking, currency, foreign affairs, all of this, the central government has the power to make laws. With respect to, there are others, etc., etc. Okay, just for example, I've given you 4. Defense, relating to defense, obviously the country's defense, and banking, currency, foreign affairs, all of these are given with the, are kept with the union list. Whereas when it comes to state list, agriculture, police, trade, etc., etc. Yes. Now, concurrent list, wherein both. Yes, joint list. This is also called as joint list, wherein even the central government also has powers, state government also has powers. Here, education, marriage, succession, and there is also one more example, stamp duty. One more example, stamp duty. If you have watched my the first lecture, I have given you an example of stamp duty with respect to transfer of property. Transfer of property, that is a state list. The power is with the state when it comes to stamp duty with relating to transfer of property. I also gave you an example of transfer of shares, stamp duty on transfer of shares. That is the state, that is the central subject. Getting it? That is union. That is for the that is a central subject, whereas stamp duty with respect to a transfer of what property or land or building, that is with the state. Getting my duty, getting my example. So stamp duty is one such example wherein both center and state have the power to make laws. Getting it? Everyone clear? I hope I am clear. Okay. See, central list, state list, and joint list or concurrent list. Okay. Now, depending on the list in which it figures, a matter would become the subject for central law or a state law. For example, income tax is a central subject. Income tax is a income tax is a central subject. So throughout India, we have only one law for income tax. There is only one law for the entire country. Yes, that is income tax, which is implemented by the central government through the Ministry of Finance. We will learn the implementation also. Okay, that is implemented by the central government through the Ministry of Finance. Okay, we also have matters for which both central as well as state governments can pass laws. Can pass laws. Both central and state governments can pass laws. Example, example is levy of stamp duty. I told you stamp duty with respect to transfer of property, state subject. When it comes to transfer of shares, it is with the government, central government. Yes. See, both, there are many others. I'm just giving you an example. Okay, stamp duty, there is levy of stamp duty on many events. That is given in the article. See, article again, it tells you which are the, it gives you the schedules, and in those schedules, it will tell you which is the state subject and which activities are related to the, on which activities the center has the power to levy duty. Getting it? This is one such example, stamp duty. Okay, fine. We are done with this as well. Okay, and the last topic for the day. Okay, we are going to complete till here and we will end the class. Okay, fine. Come to the next topic on page number 5, types of laws. Types of laws in the Indian legal system. Types of laws in the Indian legal system. Okay, you can see the types of laws. The first one being the criminal law, civil law, common law, and the principles of natural justice. Principles of natural justice, criminal law, civil law, common law, and the principles of natural justice. The types of law. Important, children. Yes, can easily come in your examination. Okay, fine. Criminal law. Okay, basically, when you read the word criminal law, obviously it is something very serious. Yes, something very serious. Yes or no? Tell me. Yes. Okay. Fine. Okay. Getting it? What were we talking? Yeah, criminal law. So yeah, criminal law is concerned with laws pertaining to violations of the rule. Underline, violations of the rule of law or public wrongs and the punishment for the same. See, it deals with law. It deals with what? It deals with violations of the rule of law or public wrongs or punishment of the same. See, they're talking about criminal offences. We are talking about criminal offences. Example, ma'am, what are the examples for criminal offences? See, murder, rape, theft, fraud, cheating, and assault are some of the examples of criminal offences under the law. See, whenever you violate the law, say for example, you have committed, someone has murdered someone. Just imagine what kind of a crime he has committed. Isn't he violating the law? Isn't he violating the law? He's cheating, or he's there is some fraud which is taking place. These are all violations or something very wrong with respect to the These are all public wrongs. Yes, these are all public wrongs. So all of these are dealt under criminal law. See, criminal law is governed under Indian Penal Code, and Code of Criminal Procedure. Yes, Indian Penal Code is now replaced by Bharatiya Nyaya Nyaya Sanhita. Okay. It is replaced by Bharatiya Nyaya Sanhita, whereas Code of Criminal Procedure is replaced by Bharatiya Nagarik Suraksha Sanhita. Whereas the Code of Criminal Procedure is replaced by Bharatiya Nagarik Suraksha Sanhita. Getting it? Just write down here. You want me to write down? Bharatiya Nagarik Suraksha Sanhita. Yes. Okay. When was this? This came into force on 1st July 2024. Very recent. Yes. So Indian Penal Code 1860 is replaced by Bharatiya Nyaya Sanhita, whereas the Code of Criminal Procedure 1973, that is, we also call it as CRPC, that is replaced by Bharatiya Nagarik Suraksha Sanhita. Yes. Now, the Indian Penal Code 1860 defines, what does it define? The Indian Penal Code defines the crime, its nature, and the punishments. Okay, these are the three. It defines the crime, the nature, and the punishments for the crimes. Okay, the Indian Penal Code. The Indian Penal Code 1860 defines what? It defines three things. It defines crime, it defines its nature, it also defines the punishments. Now, when it comes to Criminal Procedure Code, when it comes to the criminal procedure, that is nothing but Code of Criminal Procedure 1973. It defines the exhaustive procedure for executing the punishments of the crime. So, Indian Penal Code gives the punishment, defines the punishments, whereas the Code of Criminal Procedure gives the exhaustive procedure. Exhaustive meaning in detail. Yes, everything in detail. So defines the exhaustive procedure for executing the punishments of the crime. Getting it? Simple. So what is criminal law? Criminal law is concerned with the laws pertaining to the violations of what? Violations of law, public wrongs, and also the punishments of the same are also dealt with this particular law. So it is governed under what? Indian Penal Code 1860, which is now replaced by Bharatiya Nyaya Sanhita, and the Code of Criminal Procedure, which is now replaced by Bharatiya Nagarik Suraksha Sanhita. Okay, now the Indian Penal Code defines three things. What is that? What does it define? It defines the crime, it defines the nature, and it also gives the punishments. Whereas the Code of Criminal Procedures, what does it do? It defines the exhaustive procedure for execution of the punishments of the crimes. Examples of crimes. Crime meaning crime. Okay, murder, theft, fraud, rape, cheating, assault are some examples of criminal offences under this law. And we as chartered accountants, we do not study criminal law. This is not there in our syllabus. If you want to learn about criminal law, if you are very interested, you will have to do your LLB, right? Okay, we're not much concerned about criminal law. We are only concerned about civil law. We're only concerned more about civil law, business law, basically business and corporate law. Yes, okay. Now, what is civil law? What is civil law? Matters of disputes between individuals or organizations are dealt with under civil law. Give me a moment. Okay, matters of disputes between individuals or organizations are dealt with under civil law. Fine, let me give you an example. Say there is this Bengaluru Ganesh Utsav, which happens every year in Bangalore. Okay, ma'am, what is this Bengaluru Ganesh? See, as a proud resident of Bangalore, I just want to tell you that this is just an event which happens wherein all of these celebrities, a few of the celebrities are invited, and they perform, certain singing, musical contest and dance and all of these. It's just a celebration during the Gauri and Ganesha festival. Okay, it's just for your information. Okay, now what I'm trying to explain you all is that, say, um, Miss Shreya Ghoshal, you basically you are organizing this Ganesh Utsav. Let's consider that you are organizing this particular event. It could be any event, and you have entered into a contract with Miss Shreya Ghoshal, and you have also given an advance of, say, for example, 5 lakh or 10 lakh, or I don't know how much she charges, but a, a considerable amount of money you have already given it as an advance to Miss Shreya Ghoshal. Okay, for what? For her to perform at the event. For her to perform at the event. Could be any event. And now finally things don't go well, and possible reasons could be anything. Some reason she could not perform on the given date. She could not basically perform. Now you are so angry, you are so irritated, you want you want justice. You want justice. You will go to court. You will go to court and you will ask the judge to jail Shreya Ghoshal. To you want justice. You want justice. You want see okay. I'm disclaimer. Nothing personal. Okay, just for the sake of example, I'm trying to use certain names, but yeah, nothing personal here. Okay, fine. So what I'm trying to tell you is, you want to give some kind of for your satisfaction, you want you go to court and you ask for relief. Yes, you think the punishment given under criminal given under civil law is something similar to the punishments given under criminal law. Do you think it will be the same? No, right? Say for example, let me give you one more example. Say you are in trading of business. Say you're doing some business of some trade. Keep it some electronics, say laptops. Say for example laptops, and you have to resign. You have to receive a consignment from your supplier. You have to receive a consignment from a supplier, and say for example 100 laptops, and on a particular date, and for some reasons he does not send you or supply you on a particular date, or keep you haven't received the consignment. Now you are so angry, and you are very disturbed, and you go to court asking for justice. I want you hold the placard that I want justice, I want justice, and you're asking the judge that, see, we had see, he's violating, I had entered into a contract and he had to supply so and so computers to me on so and so date, and he did not do it, and I am not feeling satisfied. At least for my ego satisfaction, you have to put him in jail at least for 1 day. At least for 1 day. You think court is going to give such punishments for such silly, whatever it is, not silly, but not as serious as the murder or the criminal offenses? Do you think? No, right? So, see, we are basically talking about the matters of disputes between individuals or organizations are basically dealt under civil law. Now, civil courts enforce the violation of certain rights and obligations through the institution of civil suit. I'll come back to this later. Okay. And now, civil law primarily focuses, important, it primarily focuses on dispute resolution. Very, very important. Focuses on dispute resolution rather than punishment. It primarily focuses on dispute resolution rather than punishment. It does not, in none of the cases you will be sent to jail or whatever it is. It's just the resolution of the dispute between the parties. Say for example, there is a partnership firm, and one partner is coming in, incoming, and the other partner is going out. The outgoing partner has to be settled. He has to be given his share of money, and for some reason there has been a dispute between the parties, between the partners, and maybe his amount has not been settled. Maybe his amount has not been settled. Now, the other partners cannot be sent to jail on this particular reason, for this particular reason. The maximum the court does is to try to solve the dispute, and whatever it is, the amount or whatever, the other party will be asked to pay. Getting it? So this is something which is related to, these are nothing but civil wrongs. These are nothing but civil wrongs. Getting it? Okay, see, so the civil law primarily focuses on dispute resolution rather than punishment. I hope I'm clear. Okay, and next, yeah, the act of process and the administration of civil law are governed by the Code of Civil Procedure, CPC. That is CRPC, this is CPC. Code of Criminal Procedure, here Code of Civil Procedure 1908. Okay, civil law can further be classified into law of contract, family law, property law, law of tort. Law of tort meaning civil wrong. Tort meaning civil wrong. Okay, nothing much. Okay, fine. This is simple. Now, I just want you to come to this particular line. Civil courts enforce the violation of certain rights and obligations through institution of civil suit. Okay, what is this civil suit? Okay, civil you leave. What is this suit? What is this suit? Hearing it for the first time, feeling it weird. Civil suit. Yes. Have you ever heard of this word called sue? Have you ever heard the word called sue? I just want to tell you what happened in my first law class. Okay, I just write it down. So I just remember this day, and when I was a student, I recollect this, wherein this was my first law class, but it was not the teacher's first law class or whatever. It was not because see, I attended my foundation class. It was CPT at that point of time, and for some reason, the reason is that it's just that I'm basically from science background. So I did my PCMB, and then somehow I shifted from science to commerce, and I had to attend my CA foundation classes, CPT classes. And due to that transition, what happened was a few days of my, CPT classes I had lost. I could not attend. Because when the classes were going on, I actually wanted to I was actually searching for colleges for my medicine, for my medical. I actually wanted to do. I wanted to be a doctor, and I was in search of, you know, colleges to do my medicine. When actually the law classes were going on, actually law, accounts, economics, maths, and all were going on. I was a bit late to join the CA foundation classes. So I attend this law lecture for the first time, and my teacher is like telling A sued B, and he filed a suit against someone, and I'm just wondering what is ma'am trying to even tell us? What A sues B is what she's trying to explain in Indian Contract Act, and I am like, what am I hearing it right, or what is this? And I just asked the my friend who was just sitting next to me, and I just read the book, and it says SUES. I mean SUE. Okay, I'm like, what is this? Is there a word called sue? In English, I never knew all of it, and then I still remember that particular day wherein I asked my friend to explain what it is, and I made my doubt clear. Okay, that is what happens when you hear certain law words for the very first time. Okay, so this is one small incident which I felt like sharing it with you, because I know most of them who would have seen this institution of civil suit, they would have thought something different. Yeah, suit meaning the blazer or whatever it is. Yes, that is not the thing. Sue is to take legal action. Say, for example, if I have to take a legal action on my supplier, in my previous example, if I have to take take a legal action against my supplier, I will sue him in the court of law. In the court of law, getting it? Yes. Similarly, institution of a civil suit, meaning you will sue the party for the dispute, for the whatever dispute you both have. Getting it? Getting my point? Suit meaning you all, everyone. Yes. Okay, fine. Now, some of the examples of civil offences are breach of contract, non-delivery of goods, yes, non-payment of dues to a lender or seller, defamation, breach of contract again, and disputes between landlord and tenant. Breach of contract example, you can take that music thing, Shreya Ghoshal. She had entered into a contract to perform, and then she could not. Non-delivery, where did it go? Okay, non-delivery of goods. Simple. All of these are all civil offences. Okay, fine. We are done with civil law as well, and now we are going to start with common law. We are going to start and we are going to end as well. What is common law? Common law is nothing but the judicial precedent or the case law. We have learned this before. Yes, this is a judgment delivered by the Supreme Court. It will be binding upon the courts within the territory of India under Article 141 of the Indian Constitution, which is the okay. Did I tell you the meaning of doctrine? Okay, this is also one more word which you wouldn't have seen earlier. So doctrine meaning principle. It is nothing but principle. Okay. So principle of stare decisis. Principle of stare decisis meaning it is a Latin phrase basically, which means to stand by that which is decided. So basically, which whatever is decided by the Supreme Court of India will be applicable to the entire country. Yes, if the facts are similar. That is nothing but on all four legs. On all four legs, meaning the facts are similar to the previous case, previous decision, which previous case in which the decision has been passed by the court. Okay, the last being the principles of natural justice. Types of law. Where are we? We are in types of law. We finished with criminal law, we finished with civil law, we finished with common law, and now we are in principles of natural justice. Principles of natural justice. Okay, the natural justice, often known as just natural, deals with certain fundamental principles of justice going beyond written law. So this is nowhere written in law. As the name suggests, principles of natural justice. Principles of natural justice. This is something which a person has to get even though it is not written in law. Yes. Now, three things. The first one, three things. First one being nemo judex in causa sua. Nemo judex in causa sua. And the second one being audi alteram partem. Audi alteram partem. And the third one being the reasoned decision. Third one being reasoned decision. Okay. The first one, nemo judex in causa sua. Meaning, see children, okay, here, let's read whatever is there in the book first. See, no one should be made a judge in his own cause. No one should be made a judge in his own cause. Yes, meaning the person who is giving the decision, the decision maker should not be biased, or he should not have his own interest. Could be personal, could be financial interest. He should not have any personal interest or financial interest while making the judgment, while giving the judgment, or while passing the judgment or giving the decision. Getting it? See, no one should be made a judge in his own cause, meaning no one, I mean, the person who is giving the decision should not have his own interest, his own personal or financial interest. He should not be biased. Basically, he should not, when he is giving a decision between two parties, A and B, he should not be biased towards one. Yes, getting it? The first principle of natural justice. The second one being audi alteram partem, meaning, literally meaning, hear the other party or give the other party a fair hearing. Meaning what? It is nothing but giving the other party a reasonable opportunity of being heard, giving the other party a reasonable right to be heard. a right to be heard, and also to allow him to present his evidence, and also allow him to challenge the evidences which are given by the other party. He should be allowed to give his own evidence. You just cannot just consider, you just cannot close the case just by not giving him a opportunity of being heard, or the right to hear, of a right to being heard. Also, he has to be given the right to present the evidence on his behalf. Yes, he has to be allowed to give evidence on. He also has to be given the right to challenge the evidence which is presented by the opposite party. Simple. Yes, that is audi alteram partem. And next, the last being reasoned decision. What do you mean by reasoned decision? Reasoned decision is that when the deciding authority gives the judgment, there sorry, just a moment. Okay, sorry for that. Okay, the reasoned decisions are the rules of okay, what is the reasoned decision? Is that the decision making party has to give a good reason for his decision, which is based on law, which is based on law. Based on law meaning supported by law. Yes, clear till here? Nemo judex in causa sua, meaning the decision maker should not have any interest, personal or financial interest, while giving the decision. That is, he should not be biased. And then audi alteram partem, meaning the other party has to be given the right of being heard, and also to present his evidence, and also to to challenge the evidence which is given by the other party. Also, reasoned decision is that the person who gives the decision has to uh, make his decision reasonable, I mean on a reason which is supported by law. Getting it right? Clear? Okay. The last line, okay, an important line again. A judgment can override or alter a common law, but it cannot override or change the statute. See, common law is what? What is common law? Case law? Yes. It cannot override or change the statute. What is statute? Act. Now read. A judgment can override a case law. A judgment can override a case law, but it cannot override or change the act. Clear? See, what does it mean? Say, for example, case law could be outdated. Probably, yes, it could have been passed many years back, and now that case law, that particular judgment, whichever is being passed over many years back, that could not be relevant for this period. So, could be the plausible reason for which the present judgment is different. So, a judgment can override or alter a previous judgment or common law. That is the precedent. Yes, but it cannot override or change the statute. Statute meaning act. So the judgment cannot override the act. Clear, everyone? Till here? Yes. So what all did we study today? We started off from sources of law. Yes, sources of law being, I'm just revising in order to conclude. Yes, okay. Sources of law. The main sources of law in India are the constitution, statutes, that is nothing but acts made by the parliament and state assemblies. Then comes the precedents or the judicial decisions, also called as common law. And then in some cases established customs and usages. Okay. Then ours is a parliamentary democracy. Yes or no? People elect the members. Yes, we elect our representatives, and these elected representatives, they represent on behalf of the public. Yes, so parliament is the ultimate law making body. We learned how the law is being passed, how the a law is being made, the process of making a law. The first, when the law is proposed in parliament, it is called a bill, and this has to be passed in the Lok Sabha first, and then the Rajya Sabha, and later the assent of the president has to be obtained, and after that it will be notified in the official gazette, and the date mentioned in the notification will be the date, will be the effective date for that particular law. Yes, once it is notified and it is effective, it is called the act of the parliament. Yes. Okay. Now, after that, what did we study? Okay. Now we also studied that Government of India Act 1935 was there before constitution. Okay, that was a precursor for the constitution of India, and the main feature was that it established the federal system of government. Yes, federal meaning the powers being given to both central and state government. Okay, it was distributed. Okay, federal court was established. It has the jurisdiction of all the three, that is original, appellate and advisory. Yes, appellate jurisdiction was extended to civil and criminal cases, whereas advisory jurisdiction was to advise Governor General in matters of public opinion. Yes, it heard around 151 cases and it was there for around 12 years, and this was supplanted by India's top court, that is the apex court, or the Supreme Court, that is the Supreme Court of India. Okay, we also learnt about the constitution. Yes, constitution is the supreme law of India. It is the foremost law. It deals with the it also gives us the powers and duties of the citizens, also the powers and duties of the central and state government. Okay, yes. Next, yeah, again they're telling the lawmaking power is being distributed to the central government and the state government. So it is also called as the federal form of government, and there is three lists, the first one being central list, second one being the state list, and the third one being the joint or the concurrent list. Okay, one such example for state list would be income tax. For state subject, it would be what is that? Alcohol. Yes, and the third one being the joint list or the concurrent list, in which stamp duty is one such example. Okay, then comes the types of laws in Indian legal system. First one being the criminal law, second one being the civil law, third one being the common law, and then the last is the principles of natural justice. Criminal law. Criminal law deals with the violations of rules of law, wrongdoings, and their punishments. Okay, what are the two codes? One is the Indian Penal Code and the other one is the Code of Criminal Procedure. Indian Penal Code deals with three. What is it? Deals with crime, its nature, and the punishments, whereas the Code of Criminal Procedure gives the exhaustive procedure for the execution of those punishments. Yes, example, murder, rape, theft, fraud are all the crimes. Okay, next comes the civil law. Civil law deals with disputes between individuals or organizations, and code of civil procedure is I mean these civil law is governed by what? Governed by code of civil procedures. Yes, next here one more important line is it primarily focuses on dispute resolution rather than punishment. Okay, examples you have seen: breach of contract, non-delivery of goods, disputes between landlord, then disputes between the partners, etc., etc. Okay, next comes the common law. Common law is nothing but the judicial precedent or the case law. Okay, the judgment delivered by the Supreme Court will be binding upon all the courts in India. We also learned a doctrine meaning principle of what? Stare decisis, which means to stand by whatever what is decided. Okay, the doctrine of stare decisis reinforces the obligation of court. Obligation meaning the duty of the courts to follow the same principle or judgments which was established by the previous decisions while ruling a case by the Supreme Court, where the facts are similar or on all four legs with the earlier decision. I also told you that the decisions passed by the High Court will be applicable to that particular state. Okay, now principles of natural justice. Principle of natural justice is the fundamental principles of justice which is beyond law. It is not written. Okay, now what are the three? Nemo judex in causa sua, the second one being audi alterum partem, and the third one being reasoned decision. Nemo judex in causa sua, meaning no one should be made a judge in his own cause, meaning he should not have the person who's giving the decision should not have his personal interest, or he should not be biased while giving a decision. Audi alterum partem, meaning the other party should be given the right of being heard, and he has to be given the chance of giving the offense to present his evidence and also challenge the evidences which are given by the opposite party. And a reasoned decision meaning being when the decision maker gives his decision, it should be based on a reason which is supported by law. Yes, and also one more line: a judgment can override or alter a common law, being a case law, but it cannot override or change the statute, which nothing but act. Okay, yes, clear everyone? Everyone clear till here? Okay, we have completed till page 7. Okay, next we have enforcing the law, and all of these are quite simple. All are very basic, and see you're seeing, right, all of these are very basic topics. All of very easy. It's nothing to do with interpreting, understanding. Whatever is there, you have to learn, and you have to just reproduce it in your exam. There is nothing like you just have to uh, by heart. Yeah, nothing much in this. Very simple. Children, very simple. Okay. So, just a small message before we leave. So, if you really like the lecture, if you are wishing for more videos, please tell me how you're feeling about the video. Do you want me to make any changes? Is it good, or give me the genuine feedback? I'm very happy to read your comments. I'm always open to accept what you're trying to suggest. Okay, I feel very happy reading your comments and when you like as well, because I basically love students a lot. I love it when they like my lecture and when they try to study from me. I basically love to teach. So if you're really um, getting help from these lectures, please tell me. I would love to hear from you all. Okay, this is your law teacher, CA